Please note, views and opinions expressed in the course of this program do not represent that of OTV. Therefore, this channel is not liable to any legal action that may result from this program.
ètò ọ̀hún náà ló balẹ̀ bí ọ̀wàrà òjò sójúde yìí o á wá wùn mí kẹjẹ́ kájọ gbádùn ẹ̀ nítorí pé àní kára bomi tán káṣẹ̀ṣẹ̀ máa wá pariwo òtútù. òní ni ọjọ́ tí wọ́n ti dá tí wọ́n ní ìgbẹ́jọ́ yóò wáyé lórí ọ̀rọ̀ tó ti wà ńlẹ̀ tẹ́lẹ̀ èyí tá a ti ń tọpa ẹ̀ bọ̀. àmọ́ lónìí mo fẹ́ kẹ́ ẹ bá ń wá pèrèpìlì àbẹ́ bá ń fìdí tí a pèrè mọ́lẹ̀ o níhà bí igun bí tẹ́ bá wà kájọ gbádùn ètò tòní nítorí pé ìgbẹ́jọ́ tún ti fẹ́ tẹ̀síwájú lórí ìpẹ̀jọ́ ọ̀hún léyìí tó wáyé nílé ẹjọ́. bó bá ti wá yá yín tẹ́ ẹ fẹ́ gbọ́ tẹ́ ẹ fẹ́ mọ̀ kí lohun tó ṣẹlẹ̀ lọ́hùn àti báwo ló ṣe ṣẹlẹ̀ ẹ wá gbàpò tí ẹ jájọ jókòó kájọ fojú àyọ̀wò ètò tòní kájọ gbọ́ ohun tí wọ́n sọ ńbẹ̀ ó ti yá.
And the case of Uzodinma and Izunaso, citation supplied, Learned Senior Counsel submitted that the grant of this application will be in furtherance of the cause of justice. That this is a case in which the second respondent was purportedly declared as the winner of the election to the office of President of the Federal Republic of Nigeria, and the appellant applicants have, amongst other grounds, challenged the election of the second respondent on the ground that the second respondent presented a forged document to the Independent National Electoral Commission. That the appellants have also a challenge in their appeal, the striking out of their pleadings, raising the issue of qualification of the second respondent to contest the said election. Learned Silk also relied on the cases of Nigerian Customs Service Board and Innocent and other cases cited in this judgment. According to the Learned Silk, the evidence required to establish that the certificate presented by the second respondent to the first respondent in support of his qualification to contest the said election is the deposition from the Chicago State University, which deposition did not become available until after the determination of the case by the lower court. He contended that the appellant applicants have successfully explained the delay and difficulties in obtaining the said evidence earlier than now. Relying on Sale and Abba citations supplied, the Learned Senior Counsel urged this court to resolve the sole issue in favor of the appellants and grant the application. In response to the above argument, the Learned Senior Counsel for the first respondent, A.B. Mahmoud Esse, submitted and urged this court to dismiss the appellant's application as they have failed to meet the conditions for grant of same. He opined that election petitions are sui generis, and as such, this court, in determining this application, must take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, and based on the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the Electoral Act 2022. He stated the three conditions that has to be met before the fresh evidence can be admitted, and he urged this court to hold that the appellant's applicants failed to fulfill the conditions. In this, he relies on the case of Adeleke and Aserifa, Wata and Anyago, UBA PLC and BTL Industries, all citations supplied, amongst others. It is his contention that the appellants were tardy and were not reasonably diligent in their attempt at obtaining the documents which they seek to be received in these proceedings, that having not acted with reasonable diligence, this court ought not to grant the instant application, also relying on Obo and Enabel S. Limited. Oh my God. Learned Senior Counsel also drew the attention of this court to the decision of the court below, which has not been appealed against, that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and that their efforts to remedy it through their replies to respondents' replies were belated and were rightly refused. According to him, the deposition of Kale Westberg is irrelevant since the appellants did not raise the issue of forgery at the lower court. And relying on the case of Okwe Kenye and registered trustees of Jude Anglican Church, citation supplied is submitted that evidence not supported by pleadings goes to no issue. Learned Silk further submitted that insofar as the deposition of Caleb Westbeck is solely to disdain the certificate presented by the second respondent and attached to his form EC9 dated 17 June 2022, which the first respondent published as far back as 24th day of June 2022, the appellant's complaint in that regard is pre-election matter, which by section 285(9) of the Constitution of the Federal Republic of Nigeria is statute barred. As such, an action ought to have been initiated within 14 days of the second respondent's submission of his form EC9 or the publication by the first respondent. He urged the court to so hold. According to Learned Senior Counsel, an allegation of presentation of false or fake certificate is rooted in the criminal offense of forgery, which requires proof beyond reasonable doubt. He contended that the deposition by Caleb Westbeck, which seeks to establish a case of forgery against the second respondent without more, cannot ground a conviction for forgery of as proof beyond reasonable doubt cannot be solely based on an affidavit evidence, relying on Abubakar and INEC, Agi and PDP, Mohammed and Wamako, all citations supplied. Learned Silk argued further that the deposition of Caleb Westbeck alone does not, under our law, constitute credible evidence to establish a case of forgery. Finally, the Learned Silk submitted that this appeal, being based on an election matter where a trial court is to hear matters and deliver judgment not later than 180 days after the filing of the petition, the implication is that all evidence ought to be adduced at the trial court and judgment delivered within 180 days. That it was not the intention of the draftsman of the Constitution to allow and permit the receipt of evidence in an election matter when the court vested with the powers to receive evidence, has lost jurisdiction over the matter. He wondered what would happen now that all parties have filed and exchanged briefs with no arguments canvassed in respect of the additional evidence sought to be adduced in the instant appeal. There being no room to extend time under the pre-election and election appeals practice directions 2023 of the Supreme Court, he urged the court to dismiss the application. In his contribution in opposition to the grant of this application, Learned Senior Counsel for the second respondent, Chief Olanipekun S.A., submitted that this court is without the virus to consider the said deposition, either as oral or documentary evidence, more so when the evidence was not considered by the court of first instance within the 180 days time frame provided by the Constitution of the Federal Republic of Nigeria, relying on the recent case of Towo Womo and Ajayi, unreported, delivered on the 27th of January 2023 in this court hall. That the lower court, having lost its jurisdiction since 17 September 2023, upon expiration of the 180 days from the date of filing the petition by the appellant, this court cannot grant this application. That section 22 and 23 of the Supreme Court Act give power to order 2 Rule 12(1) of the rules of this court, and that can only happen if the lower court still has jurisdiction. Referring to Omubilari and Igbo Asoi and others, and Adegbite and Omosun, all citations supplied, the Learned Silk contended that applicants failed to satisfy the 5 conditions enunciated in those cases before this type of application can be granted. According to the Learned SAN, the failure of the applicants to have validly pleaded facts and documents sought to be received in evidence is fatal to this application. relying also in Obasi and Onwuka, Start Oil, Nigeria Limited and Induction, and others, all citations supplied. Making reference to the USA Rules on Civil Procedure 32A1A, the learned Silk opined that the failure to invite the All Progressives Congress and the Independent National Electoral Commission to participate in the deposition made in the United States renders Exhibit C and D inadmissible. More so, since the alleged forged certificate is alleged to have been submitted to INEC. It is further contention that Exhibit C and D have no utility or affinity with this appeal for the fact that there is no ground of appeal upon which they can be structured, as well as there being no accommodative issue for determination, relying on a number of cases listed in this judgment. Finally, learned senior counsel submitted that Exhibit C, D, unpretentiously attempts to allege a criminal offense of forgery against the second respondent. You find that a criminal offense must be proved beyond reasonable doubt, as provided in Section 135 of the Evidence Act, also referring to the cases of ACN and Nyako and Kaki and PDP. He concluded that the Supreme Court does not have original jurisdiction to try the case of forgery. He urged this court to refuse this application and hold that it is an abuse of court process. For the third respondent, Chief Akin Olujimi SN made submissions which are similar to those by the learned counsel for the first and second respondents. With due respect to the learned Chief Silk, I shall refer to them in the process of resolving the sole issue in this application. In the appellant applicant's reply on points of law, learned senior counsel listed some paragraphs of counter affidavit of the second respondent, which he alleges consists of legal arguments, objections, and conclusions, which he urged that they be struck out. On issue of jurisdiction, he submitted that Section 285(6) of the Constitution, which pegs 180 days for the hearing and determination of the election petitions, does not include the Court of Appeal, but only election tribunals. Learned Silk submitted that issue of qualification is for both pre- and post-election matters, referring to Section 137(1)(j) of the Constitution. He urged the court to grant this application in the interest of justice, as was done in Amechi and INEC and Obi and INEC, all citations supplied. In resolving the sole issue submitted for the determination of this motion, I wish to start from the beginning. And the beginning is the issue of jurisdiction. Whereas the respondents in their various written addresses have urged this court to grant not to grant this application as it is an exercise in futility. They opine that the Supreme Court does not have jurisdiction to look into or act on Exhibit C and D if admitted into the proceedings. The learned senior counsel for the appellants submitted otherwise. I have already summarized their various positions, and I shall refer to them as we proceed. It is elementary to state that the jurisdictional court is the authority which a court possesses to decide matters brought before it, or to take cognizance of matters presented in a formal way for its decision. In an old case of Ogun Makun and Milad Osun State, citation supplied, this court stated as follows: jurisdiction of the court is the basis, the foundation, and the live wire of access to court in adjudication under Nigerian civil process. As courts are set up under the Constitution, decrees, acts, laws, and edicts, they cloak the courts with the powers and jurisdiction of adjudication. If the Constitution, decrees, acts, laws, and edicts do not grant jurisdiction to a court or tribunal, the court and the parties cannot, by agreement, endow it with jurisdiction, as no matter how well intentioned and properly conducted the proceedings, once it is incompetent, it is a nullity and an exercise in futility. End of quote. The jurisdiction of a court has further been defined as the very fundamental and priceless commodity in the judicial process. That is to say, it is the fulcrum, the centerpiece, or the main pillar upon which the validity of any decision of any court stands and around which other issues rotate. Thus, it cannot be assumed or implied. It cannot also be conferred by a party or by consent or quiescence of parties. A lot of cases have been cited to support this. This and that is the general nature of jurisdiction. I must emphasize that the matter under which the application is brought is an appeal in an election petition. It is tried that election petition proceedings are sui generis. It has its own set of laws and rules which a court must recognize and enforce. See Buhari and Yusuf, Egba and Erobo, all citations supplied. In the circumstance of this case, this court, in determining this motion, has to take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, based on the provisions of the Constitution of the Federal Republic of Nigeria and the Electoral Act 2022. I have carefully perused page 1 of volume 1 of the Record of Appeal, and it is very clear that the petition giving birth to this appeal, and particularly this application, was filed on the 21st of March 2023, which was the last day of the 21 days prescribed in Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, for filing of election petitions after announcement of result of election. By subparagraph 6 thereof, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition, and where there is an appeal, it shall be determined within 60 days from the date of delivery of judgment of the tribunal or court of appeal. As pointed out by learned senior counsel for the respondents, the 180 days prescribed for the hearing of the petition by the Court of Appeal lapsed on the 17th of September 2023. In other words, the court below lost its jurisdiction to determine any matter in relation to the petition. This application before us relates to fresh evidence obtained after the judgment of the lower court and after the 21 days for filing election petition and after the expiration of the 180 days of the filing of the petition. What are the legal and or constitutional implications of the above scenario in relation to Exhibits A and D sought to be received into these proceedings? Several of the decisions of this court have taken care of the above scenario. One of the most recent cases decided by this court is the case of Towo, Womo, and Ajayi, the citation supplied here, wherein this court stated as follows, and I'll quote, "In the circumstance of this case, this court cannot activate Section 22 of the Supreme Court Act 2004, since the 180 days provided by the Constitution to determine the appellant's claim at the trial court has lapsed since 1st January 2023. The originating summons was filed on the 5th of July 2022 and expired on 1st January 2023 at the Federal High Court. This appeal was taken on 2nd January 2023, and there is no opportunity for the contentious issues of fact in the controversy in this appeal to be sent back to the trial court. The issue of the merit of the allegations of false information was not tried by the two lower courts and cannot be tried by this court pursuant to Section 22 of the Supreme Court Act. This court cannot do what the trial court is no longer constitutionally permitted to do by virtue of Section 285 of the Constitution of the Federal Republic of Nigeria, the Groundnum. See OK Mimiku, see APC and Marafa, all citations supplied. As stated by the appellant applicants in their application, the reliefs they seek is an order of this court granting them leave to produce, and for this court to receive fresh or additional evidence by way of deposition on oath. Clearly, the application runs foul of paragraphs 14 sub 2 and 16.1 of the first schedule to the Electoral Act, which inter alia outlaws any amendment of substance, as in this case, or introduction or addition of substance to the statement of facts relied on to support the ground of the petition after the expiration of 21 days prescribed in Section 132, sub 7 of the Electoral Act for the presentation of an election petition. There is no doubt that the deposition is one of substance, and that is, in fact, why the appellants are seeking to introduce it into this appeal. For the avoidance of doubt, I shall reproduce Section 14.2, paragraph 2A of the first schedule to the Electoral Act 2022 as follows. After the expiration of the time limited by A, Section 132(7) of this Act for presenting the election petition, no amendment shall be made. No amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 not contained in the original election petition filed. Or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition. Or 3. Except anything which may be done under subparagraph 2A2, effecting a substantial alteration of or addition to the statement of facts relied on to support the ground for or sustain the prayer in the election petition, end of quote. Nothing can be clearer than the above provision, which clearly states that a petitioner shall not be permitted to amend his petition after 21 days allowed by Section 132 sub 7 of the Electoral Act. The applicants herein have not even applied to this court to amend their petition in order to reflect the fact of forgery, and Exhibit C and D sought to be admitted into the proceedings. Facts and documents which were not pleaded in the petition have no place in deciding the dispute between the parties. I still wonder how the appellants intend to use those documents in this appeal. Let me consider an unusual submission of the learned senior counsel for the appellants applicants. It is in respect of Section 285 sub 6 of the Constitution, which states, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition. But on page 3, paragraph 2.5 of the appellant's reply on points of law, he argued as follows, quote, interestingly, And contrary to the avowed position of the respondents, we make bold to submit that there is no such constitutional limit of 180 days on the lower court to hear and determine a presidential election petition, such that can rob this court to exercise its jurisdiction in any manner whatsoever. While establishing the election tribunals to deal with election matters from houses of assembly, National Assembly and governorship elections, the Constitution gave jurisdiction to entertain disputes from presidential elections only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for elections tribunals and not for the Court of Appeal, end of quote. It is shocking to have the above argument in print. It could have passed for a friendly joke, but not for a serious matter like this in the apex court. It is even an unnecessary joke over a constitutional provision. After election petitions had suffered under the previous provisions, which allowed election petitions to be heard even until the respondent has completed his tenure, and the National Assembly dealt with the mischief by limiting the time which election petitions shall be determined, it is unfair to suggest that we go back to those dark days. My lords, there is nothing in section 285(6) of the Constitution to suggest that the Court of Appeal can hear presidential election petition without time limitation. The lower court is bound by the provision of section 285(6) of the said Constitution when sitting to hear election petition.